Hi everyone, and welcome to the video for today. We have 3 videos to discuss today, including the eagerly awaited Lindsey Duneske files update in which he faces off against Judge Washington, a real no-nonsense judge. Before we start, though, I want to thank Chapter, our sponsor for today. Because they choose the incorrect Medicare plan, the majority of people on the program wind up spending hundreds or even thousands of dollars annually. Now, you can't really blame them because avaricious brokers who are driven more by money than by assistance lead people into schemes that aren't advantageous to them. And for that reason, I decided to collaborate with Chapter. They founded their business when their parents decided enough was enough after falling for this money-sucking tactic. You will speak with a real person when you contact Chapter, who will guide you through each plan and help you select the best one for you. The call is totally free, which is the nicest part. This is the ideal moment to put some money back into your own pocket because Christmas is quickly approaching and the average senior saves more than $1,000 annually. Therefore, phone them at the number displayed on the screen or go to their website using the URL provided in the description and let a real person go over all the available options to determine whether either you already have the best plan for you or there is some money to be saved. Again, I want to thank Chapter for funding this video. Lindsey Duneske,
We're back on the record in the case of the state of Michigan versus Lindsey Duneske. You don't need to place your appearances back on. We had a brief discussion regarding all of the filings that were filed, although the defendant has an attorney in this particular case. So at this point in time, we need to make a record of what's going on in this matter, and we can go from there. Ms. Moeller, it looks like your client submitted 4 different filings. First of all, the court has no requirement because we're not a email e-filing court to accept email pleadings. We did do so. Your client was advised that there is a page limit to how much we'll accept for any one hearing. So that happened, and you should be aware that that did happen as well, and that she will need to follow any filing requirements in the future. And I believe that she represented to staff that she had filed those with the prosecutor's office. Ms. Woods is indicating she did not receive them. I don't know whether they were filed with the prosecutor's office or not. Having said that, do you have a copy of the filings that your client filed with the court?
They do, Your Honor. I received those. Those filings were sent to the court, and just now realizing they were not sent to prosecution, I have forwarded those to Ms. Woods.
Thank you.
I sent them to the other prosecutor. I apologize. Her name was Ellie, I think, because that was the one who it said she was the prosecutor for the county. So I just probably sent it to the wrong prosecutor.
So it is a he. That is the prosecutor, Ellie Savitt, and they probably did not get sent to the proper place because of the way you filed them.
I filed them the way I was instructed to file them. I called and asked for instructions, and I did what I was told. So I was told that the filing requirements were to email them, and that's what I did. So, and then I was notified after the fact that there was a limit. They made an exception because they didn't notify me. And then I told them I emailed the prosecutor, verified the email. And so as far as I know, the chief prosecutor got them. I just didn't know that I was supposed to send them to the other prosecutor too. I thought, notice the agent, notice the principal. So I thought if I sent them to the main prosecutor, any of the assistant prosecutors would get them because I didn't know which one would be on the case today.
Get the fuck out of here with all that sovereign citizen, notice the agent is notice the principal bullshit. That might work in whatever delusional world you woke up in this morning, but in reality, you have to serve the right person for it to actually count.
Ms. Woods?
Yes, Judge. I mean, I'm just opening up one of the files now. I mean, I would need time to review all of this. I would not be able to. Yeah, I would need time to review all of these, Judge.
Thank you. All right. So first of all, Ms. Duneske has counsel. So whether or not she should or has the ability to file filings in the first place is something I'm still mulling over because she has counsel. So any pleadings should come through her counsel. And
yeah, they refused to file it. So
ma'am, I didn't
Oh,
say
I'm
anything
sorry.
to you.
I apologize.
And then, secondly, these are not proper pleadings. They're not filed in the proper format. They're not filed with the proper spacing. They're not filed according to any of the court rules. So
They
that's
don't
the,
have to be though,
ma'am, I
which
just,
I put
they do.
on there.
Ma'am, if you speak up one more time, you're going to be held in contempt of court.
But I thought this was my hearing. I
Ma'am,
should be able to
ma'am,
speak on my
all
own
right.
behalf.
You're not. You're not able to speak on your own behalf unless you don't have counsel, and you need to stop talking. One more talking, it's going to find you in contempt of court, and I'm going to give you 15 days. So please stop talking. Ms. Woods is indicating that she needs time to look at those pleadings and to be able to respond. Ms. Moeller, what is your position? I haven't heard anything from you today because she actually has.
Thank you, Your Honor. Ms. Duneske and I did, prior to the last pretrial, discuss. I didn't know exactly what she was going to be filing, but I did understand the basis of her legal argument. Her and I had a conversation where I didn't agree with the grounds for filing. It is correct that I said I would not be filing this on her behalf because I found the legal argument not to be correct. At this hearing, then Ms. Duneske did file these motions, and so I would discuss it further with my management, but I would not be proceeding with these arguments at a hearing if the court were to set it for that. I understand Ms. Duneske does want to proceed with these arguments, and I believe that she's requesting to represent herself if this court sets this for a motion hearing.
Now, Ms. Duneske, are you requesting to represent yourself?
Well, I'm asserting my right to represent myself. I'm not requesting.
All right, then if you're not requesting to represent yourself, then what's going to happen is you're going to continue to have counsel.
Well, I'm asserting my right, which is much stronger than requesting. I shouldn't have to request something that I have a right to. It just should be automatic, right?
All right.
Like the Sixth Amendment
It is not
and the
automatic.
Constitution.
It is, ma'am,
Yes.
it is not automatic. So first
I mean,
of
the
all,
Sixth
ma'am,
Amendment says,
stop
right?
talking.
Well, you asked me a question. I'm answering under the
No,
Sixth
I heard
Amendment.
you. No, stop talking. So look, this is the way it's going to work. I'm going to give you what your rights are. And then if you make a choice to represent yourself, you can, after I've finished giving you those rights. Do you understand that part?
I comprehend it.
Okay.
Yes, ma'am.
So, first of all, what you're charged with is police officer assaulting, resisting, obstructing. It's an attempt. It has a maximum penalty of up to 1 year in the Washtenaw County Jail. Do you understand that part?
I comprehend that that's what you're charging with. I don't understand it because it's false.
Okay. Do you understand that that is what the maximum penalty is?
I do, which is why this is unconstitutional, because I was the victim in the case and falsely
I
arrested.
think what I'm going to do is refer her to make sure she's competent, because at this point in time, if she can't understand and she wants to use a different word, then I guess what I need to do is figure out what.
Comprehend means that I know
Yeah.
what it means. Okay. Understand means that I'm understanding the court, and I am not understanding the court because I'm challenging jurisdiction. I don't need a competency evaluation. I see a psychiatrist every month because I have ADD.
With all that sovereign citizen, get out of here. The principle of notice the agent may be true in whichever fantasy universe you woke up in this morning. But in practice, it only matters if you serve the correct person.
So if you would like me to present to you that I'm mentally fit, that's fine. But for you to say that I have to have a competency evaluation with no cause because I'm asserting my rights, that's a violation of Scherer versus Cullen. All I'm doing is asserting my right to represent myself.
Referred for competency. We'll prepare an order so she can be evaluated so we can
Well,
determine.
I object to that. I object
You
to the
can object
competency
whatever you
evaluation.
want to object to, but if you don't participate, then I'll put you in custody until we get an exam done.
But why? But you have to say that there has to be a reason. There has to be a cause for it, and I have a right to know why you are forcing me to do something that I don't want to do when I thought I had a presumption of innocence. I thought I'm supposed to not have my right.
For competency, you need to stop talking. And if you don't participate, I'm going to put you in custody. And I already placed on the record why.
Okay, and also, isn't the officer supposed to be here today to testify?
No, that is not how that works. See, you don't know anything about this, and that's why you shouldn't be representing yourself. But
I do. The preliminary exam was supposed to have witnesses.
This is not a preliminary examination, ma'am.
Oh, I thought that's what that was. I was just under the impression it
The
was a
first was
preliminary.
competency, and I'm gonna schedule this for a hearing on November 20th in person, so we can have these conversations in person and see if they go any
Well, I
different.
don't have any way to get there. I live very far away from where this is
Then
now.
I think when you get picked up and you're required to come here by police, then you'll have a way to
But
get here.
why would that be necessary? All I'm asking, I'm challenging jurisdiction, which I'm allowed to do without being retaliated against. You're retaliating against me because I'm challenging the jurisdiction of the court. And
That
that's
is
a
not what's
violation
going
of my
on.
rights.
Okay, Ms. Duneske, you either need to be here, you need to participate in the competency, and you need to be here on November 20th, or you will
Well,
be
I'm going to be
arrested.
filing with the Court of Appeals on this
Go ahead,
and the
ma'am.
Court of Claims because this
Thank
is not
you.
okay.
All right. Bond is continued for now. Once you get the notice of your actual interview from the forensic department, if you don't participate, I'll issue a bench warrant.
Okay, well,
I'm
like I
done.
said, I'm going to be objecting to.
All right.
Okay, Judge Washington seemed to have had as much Lindsey Duneske as she can take in a single day. However, it appears that her case will continue to move forward, so more updates should be available soon. We now go to Judge Simmons, another bossy judge, who yesterday had two idiots on the same docket.
On the record in the matter of credit acceptance versus Ashley Brown, 22-013536GC. Appearance, please.
Good afternoon, Judge. Francesca Servi for plaintiff P87205.
Okay, you're Ashley Brown?
Yes, I am.
Okay, today was the date that was scheduled for a hearing. This is for an objection to periodic garnishment. We received an objection from you, Ms. Brown. It states that you are objecting to garnishment because you was improperly notified of any, does that say hearing?
Yes. So I did some research and it appears that they reached out to a few of my other jobs like Kirchhoff, Champion, and I didn't get any notice of any of those. I feel like the only reason I got this one is because they sent it certified mail and I handle all the mail for my new job here at the Funeral Directors Association. But they garnished my taxes. I was not notified of any of that. When I've only found out that they garnished the taxes when I called the courthouse when I received this notice, because I was like, because they did, I saw the taxes were taken, but I didn't really look into it. But then I called the court once I received the garnishment, and they were like, oh, well, they garnished your taxes for this particular matter. But I was never given any notice of that.
And why would they send you a garnishment notice? They are not required to tell you that they are informing the IRS or your employer, but they do alert them.
Did you want to respond to her objections, counsel?
Yes, Judge, I will. Plaintiff had the writ of garnishment properly issued. It looks like that was back in July, so July 23rd, 2025. The writ was issued by this honorable court and then served on Garnishee Michigan Funeral Directors Associations, Inc. There's no court rule or statute or case law upon which plaintiff is aware that plaintiff is required to give defendant prior notice of filing its writ for garnishment, but the writ was otherwise properly issued by this court. And plaintiff would further note for the record that it sees that defendant was the person who signed the green card on the delivery of the writ of garnishment, and plaintiff still has not received the garnishment disclosure pursuant to that, despite now having noticed that defendant is the person who signed the green card, as well as, her admitting in court that she got it. So a plaintiff would ask that you deny the objection to garnishment as it's invalid. There's not a requirement that plaintiff's aware of that plaintiff has to forewarn a defendant about a writ for garnishment that was properly issued.
But you are still required by Michigan rule to notify me to, I'm sorry.
Ma'am, that's not how this works. You see how I asked her if she wanted to respond?
I understand, I'm sorry.
Okay, that's why I'm here. I'm the referee here. I get to mediate this. So you don't talk back and forth, you talk to me. So the court rule for your objection to garnishment is very clear. And there's no court rule that allows or tells you that you can even file a garnishment. That you see where you request the objection, and it gave you a section A, B, C, D, E, and F. Okay, and that's because those are actually the only ways in which the court rule allows you to object to a garnishment. You checked F, which allows you to say that the garnishment or the writ of garnishment was issued improperly or otherwise invalid, and then you wrote in that it was because it was improperly notified of any. You wasn't properly notified of any hearing. There's no hearing that comes with, you're opening your mouth to talk over me while I'm talking. There's no hearing that comes with a writ of garnishment. So I don't know what hearing you were looking for. There would have been no hearing. The other thing is, you said that it was not issued, or that writ issued after the initial hearing. Again, I don't know what you mean by initial hearing.
It's my turn to speak. I'm sorry.
That's correct. Yes.
So when I wrote this, it's because I literally was not notified of any other hearing even leading up. That's what I meant by hearing. So like, I understand that they issued the writ of garnishment, but I was never notified about a hearing for the judgment or any of these other garnishments. Like how am I supposed to respond to a garnishment if I don't have this, if I wasn't served?
Once more, they are not required to serve you with the garnishment. You were served for your first lawsuit. You only chose to take it seriously after they began deducting money from your salary, much like many other folks we see on this site.
Ma'am, you were served with the lawsuit in this matter, correct? And then you appeared before me back in December 1st, 2022. There was a joint pretrial statement that was completed. After that, you received your next court date. You were supposed to appear in this court on March 28th of 2023. That's over 2 years ago. You failed to appear. Default judgment entered against you.
I did not get notice is what I'm saying.
You failed to appear. You knew you were being sued. You were properly on notice that you were being sued, and the court sent the notice to appear for your next court date. That came from the court, and it did not get returned back to this court non-deliverable. If your address changed from the time that this court case began, it would be your responsibility to then go and notify the court, but it doesn't even appear that your address changed. So notice was sent for you to appear in court on March 28th, 2023. You did not appear. Outside of that, wait, I'm not done yet. Outside of that, ma'am, once you fail to appear, a default judgment entered against you, and the court then sent a notice of a default judgment to that same address.
Did not receive that.
So the court itself sent multiple notices to the address on file notifying you of A, to appear in court 2 years ago, B, that you failed to appear and a default was entered. Once that happened, that allowed you the opportunity, if you had responded to even the notice of default, you could have came back to the court and request to have the default set aside. But you never did that, and that's quite common. We get a lot of people that ignore that paperwork, and then we hear from them once it's time for their garnishments to take place.
Is it my turn to speak?
Yeah, we haven't heard anything we haven't received or heard anything from you on this file since October 12th, 2022.
I did not receive a notice for judgment. I did not receive any notice for judgment. I don't know if they was lost in translation because I was fighting the case. I definitely wouldn't have not appeared to that hearing.
Ma'am, you were advised by this court that you were doing a joint pretrial statement and that you would have some dates that would be kicked out from the clerk's office. You knew you were being sued.
I was advised of it, but that doesn't mean I was served.
What did you think happened after the next 3 years after you came to court? What did you think happened?
To be fair, like once I did receive the notice once I received the information about the garnishment, I honestly thought that they closed the case because they garnished my taxes. But I still was not notified of any of those things. I don't understand, like I said, how I'm supposed to respond, because I would have responded to the garnishment way before now had I known about it.
Your tax garnishment is what you're talking about?
Yes, they garnished my taxes, but I did not know that.
Okay, so and that's not even what you're here for today. You're here for a different garnishment, correct?
I mean, it's all of them because, like I said, that's not the first one that they did. They did multiple garnishments or at least attempts, but there was never any notification sent to me. How am I ever going to? I mean, how am I supposed to respond to a garnishment if I don't have any notice of it? I only responded to this one because I literally received a notice.